C. Russian government outreach and contacts. As explained in Section 4 above, the office's investigation uncovered evidence of numerous links, i.e. contacts between Trump campaign officials and individuals having or claiming to have ties to the Russian government. The office evaluated the contacts under several sets of federal laws, including conspiracy laws and statutes governing foreign agents who operate in the United States. After considering the available evidence, the office did not pursue charges under these statutes against any of the individuals discussed in Section 4 above, with the exception of FARA charges against Paul Manafort and Richard Gates based on their activities on behalf of Ukraine. One of the interactions between the Trump campaign and Russian-affiliated individuals, the June 9, 2016 meeting between high-ranking campaign officials and Russians promising derogatory information on Hillary Clinton, implicates an additional body of law, campaign finance statutes. Schemes involving the solicitation or receipt of assistance from foreign sources raise difficult statutory and constitutional questions. As explained below, the office evaluated those questions in connection with the June 9th meeting, redacted, harm to ongoing matter, not redacted. The office ultimately concluded, even if the principal legal questions were resolved favorably to the government, a prosecution would encounter difficulties proving the campaign officials or individuals connected to the campaign willfully violated the law. Finally, the evidence of contacts between campaign officials and Russia-affiliated individuals may not have been sufficient to establish or sustain criminal charges. Several U.S. persons connected to the campaign made false statements about those contacts and took other steps to obstruct the office's investigation and those of Congress. The office has therefore charged some of those individuals with making false statements and obstructing justice. 1. Potential coordination, conspiracy, and collusion. As an initial matter, this office evaluated potentially criminal conduct that involved the collective action of multiple individuals, not under the rubric of collusion, but through the lens of conspiracy law. In so doing, the office recognized that the word collude appears in the Acting Attorney General's August 2, 2017 memorandum. It has frequently been invoked in public reporting and is sometimes referred in antitrust law, e.g. Brook Group v. Brown and Williamson Tobacco Corp. 509 U.S. 209-227, 1993. But collusion is not a specific offense or theory of liability found in the U.S. Code, nor is it a term found in federal criminal law. To the contrary, even as defined in legal dictionaries, collusion is largely synonymous with conspiracy, as that crime is set forth in the General Federal Conspiracy Statute, 18 U.S.C. 371. See Black's Law Dictionary 321, 10th ed. 2014. Collusion is an agreement to defraud another or to do or obtain something forbidden by law. 1. Alexander Burrell, A Law Dictionary and Glossary 311, 1871. Parentheses, quote, an agreement between two or more persons to defraud another by the forms of law or to employ such forms as means of accomplishing some unlawful object, end quote, parentheses. 1 Bouvier's Law Dictionary 352, 1897. Parentheses, quote, an agreement between two or more persons to defraud a person of his rights by the forms of law or to obtain an object forbidden by law, end quote, parentheses. For that reason, this office's focus in resolving the question of joint criminal liability was on conspiracy as defined in federal law, not the commonly discussed term, quote, collusion. The office considered in particular whether contacts between Trump campaign officials and Russia-linked individuals could trigger liability for the crime of conspiracy, either under statutes that have their own conspiracy language, e.g. 18 U.S.C. 1349, 1959, or under the General Conspiracy Statute, 18 U.S.C. 371. The investigation did not establish that contacts described in Volume 1, Section 4, supra amounted to an agreement to commit any substantive violation of federal criminal law, including foreign influence and campaign finance laws, both of which are discussed further below. The office did not charge any individuals associated with the Trump campaign with conspiracy to commit a federal offense arising from Russia contacts, either under a specific statute or under Section 371's Offenses Clause. The office also did not charge any campaign official or associate with a conspiracy under Section 371's Defraud Clause. That clause decriminalizes participating in an agreement to obstruct a lawful function of the U.S. government or its agencies through deceitful or dishonest means. See Dennis v. United States, 384 U.S. 855, 861, 1966. Hammerschmidt v. United States, 265 U.S. 182, 188, 1924. See also United States v. Concord Management and Consulting, LLC, 347 F. Sup. 3D 3846, DDC, 2018. The investigation did not establish any agreement among campaign officials or between such officials and Russian-linked individuals to interfere with or obstruct a lawful function of a government agency during the campaign or transition period. And as discussed in Volume 1, Section VA Supra, the investigation did not identify evidence that any campaign official or associate knowingly and intentionally participated in the conspiracy to defraud that the office charged, namely the active measures conspiracy described in Volume 1, Section 2, Supra. Accordingly, the office did not charge any campaign associate or other U.S. person with conspiracy to defraud the United States based on the Russia-related contacts described in Section 2 above.